Good afternoon, Your Honors. My name is Jesse Ray. I represent the appellant, who was the defendant in the underlying litigation, Keith Lutz and Sandra Lutz. This is a little bit of an unusual issue with the appeal. It's not an appeal versus the defendant and the plaintiff in the underlying lower trial.
Rebuttal, Mr. Ray?
I would, sir. Yes, sir, please. We'll say 4 minutes.
All right.
Again, it's a case about a charging lien filed between the defendants and their attorney. The court had issued an order asking about a preliminary issue. There's 2 orders at issue in this that were brought up in this case. One is the order on appeal from Judge Bergman in March 4th, 2013, and then the court had asked the effect, essentially, my understanding, the effect of the Foster order from November 29th, 2011, and the interplay between those 2 orders as it would relate to the appellate court review and jurisdiction. I assume I'll just start with that issue. We looked at the Bergman order, the March 4, 2013 order. Just on the face of this order, this appears to be a final order that would be, applicable for appeal. The Florida Constitution and the Florida Rules of Appellate Procedure give a right to appeal a final judgment or order.
There's nothing in the later order that you're arguing about on appeal. You're really only arguing about the imposition of the charging lien, and as I read it and understand it, that was decided in Judge Foster's order back in November of 2011.
I would agree with Your Honor with regard to certain types of issues. I think that the Judge Foster order would prevent us from trying to bring an appeal about, an affirmative defense to the charging lien. For example, there was an issue with whether or not this charging lien would be based on an equitable principle of quantum merit. We couldn't at this point challenge that and say that there was an express contract that he was paid under. What we're bringing at this point is a jurisdictional challenge to this later order by Judge Bergman. So specifically, we're saying that because jurisdictional challenges are different than some of the other defenses that people raise, and that they can be brought later in the case, they can be brought for the first time.
And I understand that what your position, correct me if I'm wrong, is that while the November order reserved jurisdiction on fees, it did not reserve jurisdiction to impose a charging lien. Is that it in essence?
Yes, and just to be clear, there's a November order from the trial court that was the final judgment after trial. In that order, there is a reservation that talks about fees between the plaintiff and the defendant. And nowhere in there does it talk about or reference the defendant and their attorney. There's no reference to a lien. There was no motion for rehearing issued about that order. Later, a charging lien about the fees between the defendants and their attorneys were filed. This was ruled on by Judge Foster, and then later ruled on by Judge Bergman. And the Judge Bergman ruling, after the charging lien was filed at the end of the case, there was a bankruptcy between the plaintiff of the case. And as part of that bankruptcy, after the Foster order, there was $25,000 that was released from the counsel that my clients had to them as part of the bankruptcy. That's the issue that's at issue in Judge Bergman's order. In response to that order, we challenged that order on the basis of jurisdiction, and if not, at a very minimum, and I'm not sure the effect it would have at this point, but at the very least, the Judge Bergman order about the $25,000 would be a right to immediate monetary relief, and they would be able to appeal or get an appellate look at that for some capacity, even if it were under a different rule of 9.1303C3. But either way, we think we still have, and it is probably likely the last possible argument that would give them any kind of meaningful relief with regard to the underlying litigation. We still feel that there is the possibility to talk about the jurisdiction of the court based on the finality of the final judgment, the lack of an express reservation. We briefed the case law that the parties cited in the various briefs, do a decent job of laying out those arguments. I'm sure the court is familiar with them. They cited essentially 2 cases to say that the general reservation of an attorney between the plaintiff and the defendant. Sorry.
Am I incorrect that Judge Foster's order of November 28, 2011 gave Mr. Rutherford a charging lien and said that he had a charging lien to the extent of $46,873.75? Is that correct?
Those are the terms of the order, yes, sir.
All right. And was that appealable at that time?
It would have been appealable at that time.
So isn't the appeal that came a year or so later too late?
If there was no further order by any court, I would agree with you. We filed a notice of appeal within 30 days of the order from Judge Bergman on March 4th. That order involved specific relief that wasn't addressed in the prior order. Again, because...
Well, if that were the case, how would you ever know when the time for an appeal ran? Because there could always be another order.
Well, again, we would be able to appeal any final order within 30 days of that order. So it would be inherent in the way that the filings and the orders came out when the finality of the appeal would be. With jurisdiction, again, this is one of those issues where the courts have raised it even if the parties have never brought it up. The parties have brought it up for the first time on appeal. We feel there still is the argument about the jurisdiction for Judge Bergman to enter these orders inconsistent, we feel, that amend or modify the final judgment that didn't reserve this. The effect of all of that on the Judge Foster's position, orders entered without jurisdiction or nullity, but at the very least we still feel we have the ability to bring those arguments with respect to the Bergman order from March 2013, even if it is limited to the approximately $25,000 that is currently at issue in that case.
Just a factual question. Does the record tell us whether that 25 operators complete discharge into bankruptcy?
I believe that I'm a little foggy on exactly what was in the record, but I believe as part of the bankruptcy discharge, this was in response for waiving objections. There was a lot of problems between my clients and their counsel at the time. I came involved in this in the appeal process, and there was a lot of times where my clients felt that something was communicated that may or may not have been in the record, but there was a bankruptcy order that addressed these fees also that wasn't appealed. And the final judgment from trial wasn't appealed. So we concede there are certain things about the case that are, set in stone. Now, a jurisdictional challenge based on the idea that the court was adding to or modifying or amending the final judgment outside of the express reservations included in the judgment, we feel that there's still a valid jurisdictional challenge on that basis. To whatever effect it has on the Foster's order, we would absolutely at least have the opportunity to bring those arguments with regards to the Bergman order, and it was timely filed within 30 days of that appeal. And that might have been 10 minutes. I reserved, so unless the court has other questions, I can reserve for rebuttal.
All right, well, I'll let you reserve 5 minutes for rebuttal then.
Good afternoon, Your Honors. May it please the court, I'm Tom Rutherford, and I am the appellee. Timeliness is clearly the issue that's been brought before this court. The appeal is all about timeliness. The appellates say that in their introduction to their brief that the order that is being appealed is my motion to enforce the charging lien. Only that order. That's the only order that's being appealed. Of course, anything else would be untimely anyway. That's March 4th, 2013. This is all over my charging lien, as you've already acknowledged. The appellants say that I was late in providing notice of the charging lien, yet the jurisdiction was reserved for fees. My brief shows that I was not late, and case law that I presented shows that I was not late. This order being appealed is distinct from the earlier orders only in a few ways. It's for enforcement, and it sets sanctions for the conversion of the charging lien money that was established in the bankruptcy court as $25,000. Prior orders, much earlier orders in fact, more than 3 years earlier, had been, and those orders following that forward, had recognized my entitlement to the charging lien. This is an appeal that's not for the purpose, actually, of addressing any of the distinctions that this new order has. It's for addressing past orders. that are no longer actually appealable pursuant to Appellate Rule 9.110. Right after the entry of the November 23rd, 2009 final judgment, actually for the defendants who had a counterclaim and were awarded more than $1 million, and reserved jurisdiction for costs and fees as may be applicable, I had my motions for costs and fees and to acknowledge my charging lien heard in just a few weeks, December 10th, 2009, before a new judge, Judge Foster. Judge Honeywell had moved to the federal court. The order that resulted from that was January 11th, 2010. It recognized the charging lien, just didn't set the amount. Following that, orders on May 7th, 2010, July 23rd, 2010, August 25th, 2010, all recognized my entitlement to the charging lien. Yet an amount had not been set. Some of those earlier orders were tossing between contractual and quantum merit. I think it was the May 7th order that said quantum merit would be the basis of the charging lien. Now, those weren't appealable orders because they were non-final as to attorney fees. But on November the 28th, 2011, an order was entered by Judge Foster resulting from 2 hearings that took place earlier in September. That was a final order, as I understand it, in regards to attorney fees. It set the amount. Not only had a charging lien been determined and recognized, but it set the amount of $46,000, as Judge Wallace noted. Now, that was the only order to that date for attorney fees that actually was appealable. But it was the order that should have been appealed if there are no distinctions in this new order of March 4th, 2013. Now, all of those orders, none of them had any motions for rehearing filed. And the only appealable one, that Foster order of November 28, 2011, certainly wasn't appealed either. That's 15 months after the Foster order that this appeal was filed. During that period of time, the appellants had 6 attorneys following my $1 million judgment counterclaim. They had 6 attorneys fighting my fees. Now, there's some interesting facts that the court probably is already aware of, but I might remind the court because they were in the briefs. The appellants were sued by their commercial landlord in 2006. It was for eviction and for damages. They started their own defense. The judge, Judge Honeywell, directed them to find an attorney because their corporation was involved. They came to me. I filed amended affirmative defenses and filed a counterclaim. Litigation took place over 3 years. Judgment was eventually entered for the appellants for over $1 million, which included pre-judgment interest. Immediately after being notified that the judge had signed the judgment, the appellants terminated me without cause. Excuse me. They didn't realize that I had reserved jurisdiction for costs and fees, as may be applicable, for both sides. We had a proposal for settlement. They had a lease that provided for attorney fees, and they had won $10,000 of damages. Excuse me. Now, they didn't pursue execution of that judgment for 15 months, and then the landlord filed for bankruptcy protection. They became creditors in bankruptcy, but all this time, and now for 4 years, they're fighting paying my fee. And they've had 6 attorneys, and it's been 4 years. The argument presented by the appellants in the December 10th hearing, 2009, immediately following the final judgment by Judge Honeywell, was exactly the same as you're hearing today. In fact, I don't think that the appellants have presented any new arguments based on the March 4th, 2013 order by Judge Bergman. We've got several cases that we've cited, but two cases that are precisely on point are the Card case and the Baker case. The Card case is a second district case, and it's 2013. That case says, notwithstanding lack of express reservations of jurisdiction over the charging lien, because the issue of fees and costs was reserved, the court still could address the charging lien. Baker said essentially the same thing. It says that since the trial court had not yet taken up the issue of attorney fees and had reserved jurisdiction to do exactly that, there was no logic or equity in denying the consideration of the charging lien as to those fees. And, of course, they went on and did that. Now, the appellant's reply brief cites a case that I don't think has any application to this. It's Natsker versus Elam, and it's just not our situation. In that situation, a settlement took place, and after that, the settlement took place after Elam had been terminated, and the court had entered an order of dismissal with prejudice without reservation of jurisdiction for anything. Then Elam noticed and pursued his charging lien. Certainly, he was not timely. I was timely. I think Card and Baker are precisely on point. Now, if this court deems itself to have jurisdiction, I respectfully ask that the order be affirmed. Thank you.
All right. Thank you, Mr. Rutherford. All right, Mr. Ray, I'll let you have 5 minutes for rebuttal.
Thank you, Your Honor. A note about some of the cases and the exact significance. The Card versus Card case, in that case, they specifically state in the case there's no dispute that there was filed the notice prior to the final judgment. There's a whole slew of case law that stands for that proposition. Had he filed his charging lien before the final judgment was entered, it would be a whole different legal test. Having not filed it prior to that question, then it becomes a question of, is the reservation that the court had in the final judgment sufficiently broad to allow him to do this? Looking at the cases that he cited, the Baker versus Hostetler case, it's notable that that's not a case where we're talking about a final judgment after trial. It was an agreement a settlement agreement that vested the court with jurisdiction. We don't have a settlement agreement here. Again, there's another case, a second DCA case that came out 2 years later that specifically talks about the difference in the policies where you have a case that involves a settlement, and I read it to specifically limit Baker and Hostetler case to cases where the dismissed pursuant to a settlement agreement where the court reserved jurisdiction to consider attorney fees. So we don't have a settlement agreement here. Neither of those cases control. Instead, there is the majority of the legion of case law that involves the idea of if you file charging lien beforehand, it's timely. If you file it afterhand, you can have problems. We feel that there's problems here. I didn't hear anything that opposing counsel said that refuted the idea that the Judge Bergman order from March 2013 was in fact not an appealable order. If they lack jurisdiction there, that would be a defense that we could bring up at that point, and we feel that that's properly in front of the appeal court. The issue about the interaction between the two orders, of course, was brought up, and we were told to be ready for an oral argument. If the court would like, I'd be happy to provide supplemental pleadings or authorities that address any of that issue or answer any questions. Thank you, Your Honor.
Thank you both, gentlemen. That concludes our docket, and we'll be adjourned.
Thank you, Your Honor.